Welcome to the HR Empowerment Podcast, where we will uncover strategies and new insights from HR professionals who discuss up-to-date regulations, best practices, and the most pressing topics like diversity and equity, leadership, dealing with difficult situations, and much more that affect your bottom line and business. Thanks for joining us.
Hey everybody, Wendy Sellers here, the HR lady. Welcome back to episode 4 of 5 in our series on best practices in employment law. We were talking about, at the end of our session 3, episode 3, we were talking about a little bit about employees who don't think they really have to do their job, whether that's in person or remote, and that remote workers tend to get away with it a little bit more, or do they? And that brings me to a question for you, Hillary. Hillary Johns here, our expert attorney in multiple states. Does mediation work, and is mediation like coaching, or is that a completely different legal term?
Well, it's a different legal term. Mediation is part of the ADR, alternative dispute resolution process. It can happen either before a lawsuit's filed or after. Usually, for example, in the state of California, they usually require you to go to at least 2 hours of ADR and try to resolve your differences before you litigate. We generally put in a lot of our agreements that there's a dispute, that parties are required to go to mediation if they can, or the employer usually has to pay. I'm going to be clear to you, because they've had these situations where you've heard these huge companies with billions and billions of dollars will say, well, let's go to mediation, let's go to arbitration. And someone who's making a good salary going, look, I can't compete with that. I can't out litigate, a Fortune 500 company that's publicly traded and making all this money. So usually the employer pays for it. Mediations have limited confidentiality. They're there with either a retired judge or a trained lawyer to work out your differences. The nice thing, it used to be they put everybody in person thing. I never really was a fan of that. I like the way they do it on Zoom. They Zoom in, you have breakout rooms, you're there with your client. The mediator shuttles back and forth. It's kept relatively confidential. It's in a less stressful environment. They discuss the pros and cons of your case. Look, you've got some weaknesses here. The mediator's job is to settle it, but it's a way to settle it. It can be very satisfactory and very satisfying to a lot of people. A good settlement is usually, everybody thinks I paid too much, or I could have gotten more, but I didn't, I could have won, but a good settlement, both parties are a little like, I don't want to do it, but this is better than a trial. The reality is they are so backed up since the pandemic, and courts were backed up anyways. But I have cases that are dragging more than 4 or 5 years in civil court. And, I have to tell clients now, it could be a couple years at least before you get to trial. I mean, I really do. And when you're looking at that and how much time that is a very strong motivator to settle. I thought this would be over in a few months. I just file, or a year, maybe. No, it could be 3 or 4. It's a different matter, and it affects your other life. For companies, it's not always a good look for them. We're in litigation because we've got a claim. It could affect financing. It could affect insurance claims. If you have insurance, you do have to tell your carrier. It's not like, I rear-ended your car. Can we not tell our insurance company to call me? You need to tell them, and it can be a lot of cases are resolved through mediation. When it's over, we usually bring an agreement with us. We send it to opposing counsel and say, look, will you agree? This is what we'll sign. We get them to sign there. If you get an agreement in mediation and you don't have something in writing, they leave. They can change their mind that night and say, I changed my mind. I don't want to do it. So we try to get them to sign there. We send a draft to opposing counsel, say, are you agreeable to this? That way you have a signed agreement. And, the relief of something being over and a big conflict and a big stressful thing, because it's stressful for both parties, really. It really is. And, they've done these things where, a lot of people sue. I'm sure some attorneys do. We obviously don't, and I don't think most attorneys do. They just sue saying, well, they've probably got insurance, they'll just settle. That's not an advisable practice, but it does happen. And employers fall prey to that, where they're going to get served with something. There may not even be at fault, but they know it's cheap. They're hoping, the plaintiff's attorney is hoping that it's cheaper to settle through an insurance claim or a payout than what you're going to be paying your lawyer. And we get requests all the time. We can never guarantee what something's going to cost, but they want a budget or they want, look, it depends. And, most lawyers won't, they can say, look, if it goes this way, it may be, but it could be more, it could be less, because you don't always know. But
it's like saying, Hillary, well, I don't know. I can give you an estimate if you swear to me you're telling me the truth.
Yeah, exactly.
the more information I find that you forgot to tell me, then guess what? My cost just went up. Hey, I do have a question. You kind of mentioned this a little bit, the mediation or arbitration that it needs to be signed and agreed upon. If you intend on using mediation and arbitration regularly, does it need to be listed in an employment handbook?
I'm careful about employment handbooks because I would put it in your employment agreement. And there are some excluded, like California, for example, has the Silence No More Act, where they try to get people to go into, they try to get people to sign NDAs about sexual harassment, sexual assault. There's special law about that now. There's President Biden's. I am very careful about employee handbook. We encourage what are called policies because an employment handbook is a contract. And if you are out of date, that's going to be an exhibit at trial, seeing they're not keeping pace with the law. They don't know what it is. They're negligent. If you have a policy that's open, we encourage this. And, these are things we don't allow. We have ones that we prepare for companies routinely that are sexual harassment and discrimination and, persons with disabilities, gender, race, anything like that this is our policy. This is who you can contact, more than one person. If you're not comfortable with that, these are your options. With these sites, to the state complaint. If you don't feel comfortable talking to, this is where you can file a complaint. So we do encourage in the employment agreements to say, look, if there's a dispute, we request that you go to mediation. Often the employer has to make a business decision. We will pay for that, depending on where you are in that situation. Some arbitration is not legal to do anymore. You can't compel arbitration. And, in California, there's cases that have gone up to the Supreme Court about whether you can require arbitration or all claims have to be arbitrated. Typically, this has to do with the PAGA claim. They had that Viking Cruises matter that just came out. So I was in court last couple months, and the judge was reading the opinion from the Supreme Court. Okay, well, based on this case, the Viking, it says we can only do this. So they are following, and courts are following because they have to. And a lot of times they don't know what the law is going to be. You have to send out an update. But I would recommend that you have policies as to that. And if there's arbitration or mediation that you're going to require, I would put it in their agreement, whatever they're signing. I would have them sign a separate employment agreement. I'm not saying an employee handbook is not a good idea, but we usually call it a resource book, or we have company policies and things like that. Because if you don't have it, it is a contract. And if it's out of date or you have an illegal provision, then
everything's gone. Or it's more material for the opposing lawyer. So, well, thank you so much for that advice. That is amazing. Thanks everybody for listening to episode 4 or 5 of our 5-part series on best practices in employment law to avoid having to go to trial, to avoid having to end up in the newspaper and everything else. I want to cover a few more things that we have already talked about, but we kind of glossed over. And in episode 5, I want to talk about the fact that you volunteer and you are a pro bono attorney. So everyone, we will be right back.
Thank you for joining the HR Empowerment Podcast, brought to you by Aurora Training Advantage. We hope you've gained new insight and strategies to navigate the HR profession. We look forward to you joining us again on the HR Empowerment Podcast.